There are moments in legal proceedings when the machinery of justice, having moved slowly and deliberately for months or years, suddenly accelerates toward conclusion, when the theoretical becomes practical, when judgments transform from numbers on paper into sheriffs at the door. For Donald Trump, that moment has arrived, and the panic is palpable. The New York civil fraud case against Trump has entered its enforcement phase. Judge Arthur Engoron ordered Trump to pay $354 million in penalties for systematically overinflating the value of his assets to secure better business deals. With interest accruing at $87,000 per day, the judgment now exceeds $454 million. Trump has until his deadline to either pay in full or post a bond covering the entire amount. If he fails, Attorney General Letitia James can begin seizing Trump properties across multiple states. Think about what that timeline means. Trump's lawyers filed emergency motions claiming that posting a $454 million bond is practically impossible. They said they approached 30 bonding companies. All 30 refused. They spent countless hours negotiating with one of the largest insurance companies in the world, still could not secure a bond. That is not normal for a supposed billionaire with a massive real estate portfolio. That is financial desperation. Letitia James did not mince words when asked what happens if Trump does not pay. If he does not have funds to pay off the judgment, then we will seek judgment enforcement mechanisms in court and we will ask the judge to seize his assets. A reporter asked which assets specifically. James, standing outside her office, looked across the street at 40 Wall Street, a Trump-owned office building. We are prepared to make sure the judgment is paid to New Yorkers. And yes, I look at 40 Wall Street each and every day. Notice what former White House Press Secretary Stephanie Grisham revealed about which properties would hurt Trump most. She told CNN, "I think if she tried to seize Mar-a-Lago or Bedminster or Trump Tower, those are his babies. You've got Sterling Golf Course in Virginia. Any of the properties with golf courses, I think, would absolutely devastate him. It will be interesting to see what she goes for." That is someone who worked directly in the Trump administration explaining that these are not just business assets, these are Trump's identity. This becomes even more devastating when you understand how Judge Engoron's ruling systematically dismantled every property valuation Trump claimed. Mar-a-Lago is a perfect example. Trump valued the property between $750 million and $1.5 billion. He claimed it as a residential estate. The judge found Trump fraudulently inflated its value by perhaps 10 times its actual worth. Why? Because the deed from 2002 legally restricts Mar-a-Lago to non-residential use. Trump signed an agreement with the town of Palm Beach converting the property to a private club. The agreement explicitly states members cannot stay more than 21 days per year. Trump valued it as if he could sell it for residential development, but he cannot. The deed prevents it. A 20/20 appraisal found the market value at $78 million. Trump claimed over $1 billion. That is more than 10 times inflation. Every single Trump property Judge Engoron examined showed the same pattern of fraudulent overvaluation. Trump Tower penthouse in Manhattan. Trump claimed it was 30,000 square feet, valued at $327 million in 2016. The problem? The court was shown a document Trump signed in 1994 acknowledging the true size of the penthouse is 11,000 square feet, not 30,000. Trump nearly tripled the square footage on financial statements from 2012 onwards. When a Forbes article in 2017 revealed the truth, the Trump organization quietly revalued the property down to $116 million, but continued using inflated valuations elsewhere. Think about the magnitude of fraud here. At 40 Wall Street, the office building, Trump claimed it was worth between $297 million and $345 million in 2020 and 2021. A professional appraisal in 2020 found the market value at $200 million. Trump inflated by over 40%. Seven Springs Estate in Westchester County. Trump valued undeveloped land between $261 million and $291 million. Professional appraisals listed the potential development worth as $45 million in 2013. The golf course itself was worth $16.5 million, according to a 2014 appraisal. Trump inflated by hundreds of millions. Judge Engoron found Trump, his company, and executives, including sons Eric and Donald Jr., liable for falsifying records, conspiring to defraud insurers, and issuing false financial statements. He also found former Trump Organization executives Alan Weisselberg and Jeffrey McConney liable for insurance fraud. This was not a close call. This was systematic, decades-long fraud affecting billions of dollars in loans and insurance policies. What happens next in the asset seizure process explains why Trump's emergency filings show absolute panic. Under New York state law, defendants seeking appeal must post a bond worth the full value of the judgment to stop the state from collecting while appeals play out. Bond companies typically require 1.2 to 1.5 times the judgment amount to account for costs and interest. That means Trump needs somewhere between $545 million and $681 million in liquid collateral, not real estate, cash, or marketable securities. Former New York Assistant Attorney General Adam Pollack explained that bond companies have strict rules. Real estate is not allowed as collateral because it cannot be liquidated quickly. Trump's claim that 30 bonding companies all refused him tells you everything about his actual financial position. Pollack said about Trump's emergency filing, all 30 of them would absolutely write Trump a bond if he offered $500 million of cash collateral, and 0 of the 30 will offer a bond if he offers anything much less than that. Translation: Trump does not have the cash. Trump's wealth is tied up in a liquid real estate that he fraudulently overvalued for decades. Now, when he needs actual liquid assets to post a bond, he cannot produce them. Think about what Letitia James can actually do if Trump misses the deadline. First option, most straightforward. James already has a complete roadmap to Trump's finances from the civil fraud investigation. She knows exactly where his assets are held. She can direct the New York City sheriff or marshal to go to Trump's bank and issue an execution order demanding Trump's accounts be drained. State law protects $3,000. Everything above that gets seized. Pollack says this is the most efficient route to getting $454 million. James can also seize Trump's LLC membership interests, shares of stock, and other financial investments. Or she can begin seizing properties, not just in New York. Thanks to the Uniform Enforcement of Foreign Judgments Act, requiring states to give full faith and credit to official acts and judgments from other states, James can technically go after Mar-a-Lago in Florida, Trump National Doral Golf Club in Miami, Trump Tower Chicago, any property anywhere in the United States. Florida homestead protection that Trump is counting on might not actually protect Mar-a-Lago like he thinks. The Florida Constitution exempts every resident's homestead from forced sale under process of any court. No judgment, decree, or execution shall be a lien. Attorney Colleen Kerwick explained that Florida is a debtor's haven. The homestead law protects an unlimited amount of value in a residential home from judgment creditors. But here is the problem. To qualify, you must live in a home you own and maintain the home as your primary residence. Mar-a-Lago is not residential property. It is a private club. The 1993 agreement converting it to a club explicitly bans members from staying more than 21 days per year. Trump's own attorney said in the past that Trump was not living in Mar-a-Lago, was only a member of the club. Notice the legal trap Trump created for himself. When he valued Mar-a-Lago as a residential estate worth $1 billion for loan applications, he claimed it as development property. Now, when trying to protect it from seizure under the Florida homestead exemption, he claims it as a primary residence. It cannot be both. If it is residential, then his financial statements were fraudulent because the deed prevents residential development. If it is club property, then it is not protected by the homestead exemption. Either way, James has a legal pathway to seizure. Think about the timeline pressure Trump is facing. Interest accrues at $112,000 per day, according to Associated Press calculations. Every day Trump does not pay, the judgment grows larger. By August 2025, Trump's bill climbs to $500 million, and that is just New York's civil fraud case. Trump also owes $88.3 million to E. Jean Carroll from a separate civil trial. Combined, Trump needs over $540 million in liquid assets immediately. Trump filed emergency motions arguing bond requirements are impractical and unjust. He claims securing such a large bond is a practical impossibility. The appeals court initially said Trump must post the full amount. After Trump's lawyers complained, the court reduced the requirement to $175 million. Trump posted that bond in April to halt collection while appeals proceed. But if appeals fail, Trump still owes the full $454 million plus accumulated interest. And Letitia James made clear she will seize assets to collect. What happened during the trial reveals how thoroughly Judge Engoron documented Trump's fraud, making appeal nearly impossible. The trial lasted 2.5 months. 40 witnesses testified, including Trump himself. The judge decided the case because state law does not allow juries in this type of lawsuit, and neither side requested one. Before testimony even began, Engoron issued a summary judgment ruling that the state had proven Trump fraudulently inflated financial statements. Trump's defense argued that disclaimers on the statements absolved him because they said recipients should not rely on the numbers. The judge rejected that defense. He found decades of systematic fraud designed to deceive banks, insurers, and business partners. Specific examples of fraud the judge found are absolutely damning and make successful appeal unlikely. Trump Organization CFO Alan Weisselberg testified under oath about how valuations were manipulated. He said he and Trump Organization controller Jeffrey McConney agreed to report the value of Trump Park Avenue as if rent-stabilized apartments could be sold at market value, even though legally they cannot. 12 rent-stabilized apartments were appraised by a bank at a total of $750,000. The Trump Organization claimed they were worth $50 million. That is 67 times inflation. Weisselberg also said he valued Mar-a-Lago as if it were residential, even though legally it is not. Notice what happened when Trump Organization Assistant Vice President Patrick Burney testified. He said a 2017 Forbes article revealing Trump's penthouse-size claims were overstated prompted a revaluation. He, Weisselberg, and other employees revalued the property at $116 million in 2017, down from $327 million in 2016. But Burney testified he researched Palm Beach homes to value Mar-a-Lago and did not learn of the property's 2002 deed classifying it as non-residential until the Attorney General pointed it out. The court was also shown draft spreadsheets Burney prepared in 2017 proposing marking up the value of some Trump assets by 15 to 35% under the guise of a presidential premium. Think about what Trump said during the trial when he testified. He told reporters Mar-a-Lago was worth between $750 million and $1.5 billion. This is after professional appraisals found $78 million value, after deed restrictions were proven, after fraud was documented. Trump still publicly claimed the property was worth 10 to 20 times its actual value. That is why the judge found fraud continuing through the present day. Emergency filings. Trump's lawyers submitted show desperation bordering on panic. They claimed bond requirements would force a fire sale of properties. They argued no bonding company would work with them despite being one of the largest insurance companies in the world. They said posting collateral is impractical without explaining why a supposed billionaire cannot access $500 million in liquid assets. James's office responded that it is common for large companies to post billion-dollar bonds. They suggested Trump should have posted real estate with the court. Trump's team argued that is impractical and unjust, but cited no New York case law supporting the claim. What Letitia James said about which property she is eyeing reveals this is not an empty threat. This is active preparation. James looks at 40 Wall Street every single day. The property is directly across from her office. It is Trump-owned, subject to fraud findings, located in New York where she has immediate jurisdiction. It is a perfect first target for seizure. But James also filed judgments with the clerk's office in Westchester County on March 6th, just 1 week after Engoron made his decision official. That is where Seven Springs Estate is located. James is preparing legal groundwork for seizing properties across New York State. Even if Trump somehow survives the New York seizure threat, this case has destroyed his business empire in other ways. Judge Engoron also banned Trump from running any New York-based corporation for the next 3 years. He ordered the Trump Organization to supply detailed information to a court-appointed monitor about all financial operations. The monitor is retired Judge Barbara Jones. She gets full access to day-to-day operations, advance notice of any efforts to secure bonds, any financial disclosures, any representations made in connection with securing bonds, any personal guarantees, any obligations required by surety companies. Trump's business is essentially under court supervision. Think about what this means for Trump's political future. He is running for president while facing potential seizure of properties he built his entire brand around. Every campaign rally he holds, interest accrues on the judgment. Every day he does not pay, the judgment grows larger. Every property he owns is potentially on Letitia James's seizure list, and bond companies will not work with him because they do not believe he has liquid assets to back their risk. Trump filed bankruptcy in the past for casino properties, but filing personal bankruptcy would not make the $454 million fine disappear. It would just hand control of assets to a bankruptcy court and trustee who would sort out debts and prioritize who gets paid. Taxes always take priority, then judgments. Bankruptcy would delay things. Trump's debts could take years to settle, but interest would still accrue on outstanding balances. Meanwhile, James could argue that a bankruptcy filing proves Trump does not have assets to pay, so the court should authorize immediate seizure regardless of what happens with appeal or bankruptcy proceedings. The damage is already done to Trump's business empire and personal brand. Judge Engoron's ruling was based on overwhelming evidence, 40 witnesses, 2.5 months of testimony, documents showing systematic, decades-long fraud, financial statements proved false, property valuations proved inflated by hundreds of millions or billions. Company executives testified under oath about manipulation. Trump's own signed documents contradicted his claims. An appeals court is unlikely to overturn findings this thoroughly documented. This represents more than a legal defeat. It represents the exposure of a decades-long con. Trump built his political career on the myth of business genius, the self-made billionaire, the deal-maker extraordinaire, the man with the golden touch. This case has demolished that myth with the precision of an accountant's spreadsheet. The fraud was not subtle. It was not borderline aggressive valuation. It was systematic, lying on a massive scale, tripling square footage, ignoring deed restrictions, inflating values by 10 times or more, and doing so year after year, deal after deal, financial statement after financial statement. What makes this particularly damning is that Trump continues to lie even after being caught, even after professional appraisals, even after his own employees admitted the fraud under oath. Even after a judge spent months documenting every inflation, Trump still claims Mar-a-Lago is worth 20 times what appraisers say. This is not someone who made mistakes. This is someone who cannot stop lying even when the lies have been proven false. The question now is whether Trump will face actual consequences. For decades, he has avoided them through delay, appeal, settlement, and bankruptcy. He has treated the legal system as a tool for postponing accountability indefinitely. But this time feels different. The judgment is clear, the fraud is documented, the timeline is set, and the Attorney General has both the authority and the will to seize assets. If Letitia James follows through, if sheriffs actually show up at Trump properties, if 40 Wall Street or 7 Springs or even Mar-a-Lago get seized to satisfy this judgment, it will mark a historic moment, not just in Trump's career, but in American accountability. It will prove that even the wealthy and powerful must eventually answer for fraud, that lying to banks and insurers carries real consequences, that the law applies to everyone. But if Trump manages to delay again, if the appeals somehow succeed despite overwhelming evidence, if political pressure forces a settlement, it will send a different message. That fraud pays if you are rich enough. That lying is acceptable if you can afford enough lawyers. That accountability is for ordinary people, not for those who build empires on deception. We will know soon which message prevails. The deadline approaches, the interest accrues, and Letitia James looks at 40 Wall Street every single day. What are your thoughts on this case and its implications for accountability? Should wealthy individuals face the same consequences as ordinary citizens for fraud? Share your perspective in the comments below. And if you found this analysis valuable, subscribe for continued coverage as this historic case reaches its conclusion.